On the other hand, the contentions of the opposite parties, being the state as well as the defector complainant, are that there is enough material collected against the petitioners during investigation to establish the offence under section 498A of the IPC, and that it is a fallacious proposition that the FIR as lodged does not indicate any ingredients to constitute the offence under section 498A. They have asserted that according to the FIR, the petitioners have been instigating the complainant to commit suicide, and she has become so desperate that she has specifically stated therein that she is unable to bear the torture being inflicted upon her anymore. It is an admitted position that the FIR as lodged does not describe anywhere as to how any physical torture or cruelty was inflicted upon the complainant. As such, to some extent, the contention that the requirement of the possibility of grave injury or danger to the life, limb, or at least physical health of the complainant in terms of explanation within bracket A might be ruled out. It is also correct that there is no allegation in the FIR to the effect that the complainant was subjected to harassment with a view to coercing her to meet any unlawful demand for any property of valuable security. On the other hand, the FIR itself states that the discord between the parties was on account of the allegedly immoral lifestyle of the complainant's husband and the support he was getting from the rest of his family members when the complainant requested him to mend his ways for a harmonious family life. It is also a fact that in the face of such alleged urgings, the complainant does not appear to have resorted to anything in the nature of suicidal attempt. It has been argued that such instigation, even if admitted for the sake of argument, in itself are not sufficient or likely to drive the complainant to commit suicide, which is one of the requirements of explanation within bracket A to section 498A. However, the element of mental cruelty upon the complainant by way of such instigations cannot be totally ruled out. Whether the nature and magnitude of the same is sufficient to cause a danger to her mental health is essentially a question of detailed analysis, and there cannot be any watertight yardstick to rule out any such danger summarily. So, it would be extremely undesirable to remain smug on a premise that such verbal instigations are not so severe or of such nature as to actually drive the woman concerned to commit suicide, simply because there is nothing to indicate from the FIR that the complainant ever took any actual step in the nature of an attempted suicide. It cannot be gainsaid that there is any objectively accessible threshold to be crossed in order to determine how repeatedly or intensely a person can be actually instigated to commit suicide. That essentially depends upon various factors and circumstances peculiar to each case. the commonest of which would obviously be the sensitivity and mental make-up of the intended victim. One person can be so sensitive as to resort to a desperate act even on a casual instigation. Another, who is mentally tough, may not be affected even if repeatedly and intensely instigated. Thus, in view of this court trying to test the allegation of instigations in order to conclude whether they are sufficient to actually drive the complainant towards suicide would be too dangerous a proposition for the purpose of ruling out mental cruelty upon her. If you have liked the video, hit the like button and consider subscribing.